Hello everyone, thank you for joining us this morning. My name is Liz Deepers and I'm from ARACY. ARACY believes that every child and young person is entitled to a good life and the opportunity to thrive. And we are proud to support this, the fourth roundtable in the Act for Children campaign. Some quick housekeeping before we begin. There will be time for Q&A and we encourage you to pose your questions and submit these via the chat box. The session is being recorded and we will circulate the recording link via email as well as on the ARACY YouTube channel. It's my pleasure to now hand over to Anne Hollonds, National Children's Commissioner.
Thanks, Liz, and hello everybody. As Liz said, I'm Australia's National Children's Commissioner. My name is Anne Hollonds and I'd like to begin by acknowledging that I'm on the lands of the Camaragal people of the Eora Nations, and I pay my deep respects to their elders past, present and emerging. And I also would like to acknowledge all of the First Nations people and adults and children who might be joining our webinar today. As Liz said, this is the fourth roundtable in the Act for Children campaign. We've called it Making Rights Real, Global Insights for Australia. And we have a record 424 registrations today. And I was really excited to see a lot of names on the list that I didn't know and didn't recognise, which is brilliant. So the word is getting around that there are some important things we need to be talking about for the future of Australian children. This is a very difficult week in Australia for all champions for children's rights, and especially for children and young people in Queensland and for their families and their communities. The proposed changes to youth justice legislation in Queensland just this week highlight how much work there is to do and how much we have to learn from other countries that are moving forwards, not backwards. Our special guests, who I'll introduce in a minute, they've generously stayed up very late in their time zone, and they're each going to speak for about 10 minutes, and then we'll go to Q&A. So as Liz said, please post your questions in the chat. It's now my very great pleasure to introduce to you, without any doubt, two of the world's eminent academics, leaders and advocates for children's rights. You've seen their biographies in the promotional material, and because of limited time, I won't read them in detail. But let me firstly and warmly introduce to you Professor Laura Lundy. Laura is going to speak second. She's the co-director of the Centre for Children's Rights and Professor of Education Law and Children's Rights at Queen's University Belfast. She's also Professor of Law at University College Cork and a barrister at law. She's co-editor-in-chief of the International Journal of Children's Rights, and a very warm welcome to you, Laura. Professor Ursula Kilkelly is at the School of Law, University of College Cork, and has been researching international children's rights for over 25 years. She's an authority on the implementation of the Convention on the Rights of the Child, with a massive number of major research studies and papers on this topic. And I'd just like to say I'm indebted to you, Professor Kilkelly, for your advice in the early stages of our Helpway Earlier project, which was tabled in Federal Parliament in August. And I particularly remember a conversation we had when I was in Central Australia and you were in Ireland, and it really highlighted not only the geographical differences, but also the very great cultural differences between countries, which is one of the challenges, I think, in terms of implementation of the convention that I'm sure you'll be talking about. So thank you so much, both of you, for being with us for this conversation this morning. And over to you, Ursula.
Thank you, Anne, and good morning, everybody. It's a great pleasure for us both to be with you and to be part of what we know will be a mutually beneficial conversation about the ways in which the convention can be given life and made real in the lives of children. And Laura and I have worked together on this topic for many years, and we're both extremely passionate about what the convention can do in the lives of children. But we know that these are sometimes difficult conversations too. And we have a huge amount of experience that we've gathered in various studies we've done around the world and here in Ireland. And we're really pleased to have the opportunity to share some of that with you in the short time that we have this morning. And as I said, we really look forward to this being a conversation, because every time we do something like this, we learn so much as well. So we look forward to that. Laura is going to be my trusty assistant and move on the slides. So what I wanted to open with is an acknowledgement that this is a journey. For almost all of us, it starts with ratification of the Convention on the Rights of the Child. And it follows on then from that into a range of measures which take different forms at different times under the banner of implementation under Article 4 of the Convention. But more recently, we've seen that states around the world, for lots of different reasons and in lots of different ways, are looking to give further effect to the Convention at a national level, in national law and sometimes in national constitutions. And this whole process of incorporation is the one that we've really been looking at more closely in recent times. And I think it's really interesting that, notwithstanding all of the challenges that children's rights face, the human rights face, we're seeing this trend emerging around the world, a momentum building towards greater attention to this form of implementation, legal implementation of the Convention. And over the years, as we've looked at what the Committee on the Rights of the Child have said and done about this, it's really interesting to see that in your case in particular, and in other cases too, they've been quite categorical about the importance of incorporation, of bringing the Convention into national law in whole or in part. And so really interesting that in 2019, it made such an explicit recommendation in your case. But we also want to acknowledge that in many countries, and I think yours is probably no different, these are difficult times and difficult conversations about children's rights, about international law and international human rights law, and about the Convention. But for many, it is actually these low points that not just drive us on, but actually drive the agenda towards something better. And so we don't feel that you should be concerned about where you are right now, but rather focus for the time that we have on what's possible. Some examples here of what states have done and what it tells us. I know you've heard from Bruce about the Scotland experience. Really interestingly, they were motivated by who they were not, rather than what they were, if you like, trying to be, distinguishing themselves from their neighbours. We see opposition coming as this part of this process of incorporation from unusual places at times. Family lawyers sometimes are not on board. And in Sweden, we saw in our study, the opposition to incorporation came from judges who didn't want the obligation and struggled with the idea of how they would go about giving meaning in the courts to very general convention provisions. We also see an opportunity in countries that are highly federalized, that are sometimes fragmented, where we see the national government sitting back and not taking on their express obligation to implement the Convention and give it legal effect. But actually, we see that making way from the regions or the communities at a local or a regional level taking the lead. So there are opportunities in what might seem to be a negative perspective or position. And Norway, our example here, is really, if at first you don't succeed, Norway undertook a review to see what measures it was going to give effect to, what treaties it wanted to incorporate, and decided that the CRC was not among them. It came back to that decision a number of years later and then decided to incorporate. And also we see from that point on a really interesting series of measures that have been taken, including the courts attaching legal authority to the committee's general comments in their law. So really interesting things can happen in sometimes an unexpected way. And I wanted on that theme to talk a little bit about Ireland as an example. Ireland is perhaps unusual. It's becoming an unusual sort of poster child for the measures that are possible under the heading of implementation. We ratified the convention in 1992. We were and still suffering from a legacy of child abuse that seems to know no limits or bounds and is contemporary with us to this day. It's a paternalistic society dominated by the Catholic Church over many decades, but it has on the positive a really strong and dynamic children's rights community, and that has proven to be instrumental for us. We also cared and care a lot about what the Committee on the Rights of the Child says. And very early on, the committee pointed out our need for a national children's rights institution, a national strategy, a longitudinal study, and critically, a cabinet, a government minister for children. And these steps were taken very early and have proven again to be quite pivotal in our children's rights implementation journey. For reasons related to the legacy of child abuse, largely, we amended our constitution by public vote in 2012. In case you think that was a resounding success, the turnout for that, we don't have compulsory voting. The turnout was 33.5%. That's how much we cared about changing our constitution. And in fact, the vote was went through at a 58% success. So this was a marginal topic of limited interest. But nonetheless, we got into our law, not an incorporation of the convention, but a recognition that children are rights holders. And also really interesting, indirectly incorporating provisions that literally allow our Parliament to give legislative provision to Articles 3 and 12. So really very modest. But from there, what we've seen is the courts taking this on seriously in terms of the laws that have been passed, in terms of how the courts are operating, increasingly looking to engage and learn and want to know more about how they can give effect to these rights in practice. And we see also in Parliament, led by our Department of Children, a really interesting focus on compliance with the Convention. We're in the process of a whole new legislative review of Irish law with the government commissioning Cork to undertake a compliance, to develop a compliance framework so that they can start looking at how better to pass laws that are consistent with the Convention. And we have a raft of policies, some of which led by Laura, and in particular in relation to participation, where we've really seen an appetite for policy that is rights compliant, and Laura will come back to that. So what we've seen after this 30 plus years of journey is incorporation now finally coming into view, being set as a destination for certainly civil society and our National Children's Rights Institution, but really also been picked up now by government. So it's a really long but positive, ultimately, story, and one which highlights that this is a journey which really needs to be seen in the long game. I'm going to pass over to Laura.
Thanks, Ursula, and good morning, everyone. I'm going to pick up on some of the things that help to bring incorporation around. Again, it's based on the work that Ursula and I have been doing in this area, I think, since 2012. I mean, the obvious one, probably doesn't need to be said to you. You need political will if you want to get your law changed. You need your politicians to want to change it. So there needs a sustained campaign of working with politicians and listening to them, listening to their concerns. And there will be politicians who will want to be on board. They'll see this as something that where they can make a difference and they get it. But of course, political will mirrors public opinion. And at the same time, there has to be a lot of work doing with public engagement, some of the issues that perhaps are appealing to the public. And there's so many things that are, particularly around child protection, for example, is a point where usually people can agree. Other things, of course, are more controversial. We have seen there are always influencers. Sometimes it's a region, for example, it could be one of your states. In the same way that Scotland decided to rush ahead within the United Kingdom, we've seen that all over the world where there is federated approaches. People, you need champions. You need someone who absolutely identifies himself with it, but it's the champion who also can bring other people with them. So that kind of skill set of saying this has to happen, this should happen, and playing that role in convincing people. And it can be a politician, it can be a policy maker, it can be a children's commissioner, it can be all of those things, but they will be incredibly important in bringing about that change. Certain institutions, and sometimes that again, like regions, it could be one government department, one government agency starting to really work with their law, their policies, and that again can really change and encourage others to do so. I'm going to say something about children and young people later, but again, we saw that very much in Scotland when children and young people themselves really rallied around a campaign to say that these are our rights and why aren't you getting on with them in different ways, and they themselves very much engaged with politicians. But generally speaking, you can see that there will be very informed and organized coalitions. Civil society needs to come together. And of course, that's not always easy anywhere because people have different agendas, different priorities, but it will be necessary that there is an agreement that the convention should be incorporated into law, and getting people together in a room or in virtual rooms, agreeing what that would look like is crucial. And then finally, I'm not going to do a lecture on the general measures of implementation. I'm sure that most of you know what they are, but they are all supportive foundational steps to incorporation. Ursula's already mentioned the importance, for example, of a children's minister, which would be one of the general measures. But non-legal measures, we know they're paving the way. They have a gradual and transformative effect. And I'm going to talk just very briefly about one of them, and that's policy. Now, I'm not here to say that policy is a substitute for law. I don't think it is. But what we do know is that it can be a pathway. It's an easier step in some ways to get child rights-based policy because, of course, you don't have to put it through Parliament. It's not binding. It can be turned over in the next kind of political change. So policy in itself, though, getting people to think about what child rights-based policy is a really significant thing to do. I've just got a little table there written with my colleague Brona Byrne, and we tried to articulate as part of the Scottish process to incorporation. We produced it for them initially, is that what makes it different? What makes child rights-based policy different from ordinary childhood policy? And it is in particular that explicit and consistent reference to the convention. Not just a statement that the convention underpins everything, that's pretty much meaningless. It's actually targeting and saying, if you're writing education policy, what are the rights in education? If it's justice policy, what are the rights? And again, you can look at this in your own time, but it's an entry point and a pathway and a supportive environment in which you can then develop law, which of course then turns into policy. The little images there are from Malta. I know there are lots of Maltese in Australia. I learned that when I was in Malta last week or the week before. And Malta has done that. And it's not a normal society where you would expect this rush towards child rights, but they have a ministry of social justice or social policy and children's rights. And they have adopted a campaign called Empower Children. And it's very strongly rights-based. It's got education for children. It has child rights-based policy. These are some of the child-friendly versions. And you just start to see that there is a conversation in Malta about children's rights, which of course is going to feed into incorporation in law itself. And then finally, we know, and we have seen this, particularly most recently in Scotland, that the process can be, in brackets, nearly as important as the product. I don't want to say that the product is not important. And I know, speaking to Bruce Adamson, who spoke to you recently, he would say that if the product hadn't been visible, the process might not have been as effective. But we've seen it in all of the countries that we've studied. That even having the conversation, what you are doing tonight, what you're doing in this campaign is a child rights building exercise with huge value in itself. The first is capacity building because people are learning about rights. And again, that of course is an obligation under the convention. The partnerships I've already mentioned. And again, we've seen some of the allies are unlikely sometimes allies. And I think they're the most interesting people to talk to. The image that I have on the side is a Northern Irish bus, and the person in the green hoodie is our new Commissioner for Children, Chris Quinn, and he has decided that he wants incorporation too. He's seen what Scotland did, and he has a campaign called Road to Rights, and he's literally on the bus going around Northern Ireland, having conversations in schools, in community centres, all over, introducing the idea. And also, we are supporting him to have conversations with our lawyers, with our churches, with our politicians, with our social services staff. These are the conversations that need to happen. So we all work towards a common goal. Child participation, I've mentioned already in terms of Scotland. I mean, this is one of the areas that I do most of my work in, apart from incorporation in law and policy. You can't do it without them. It just isn't credible anymore to do any child rights endeavour without a very strong child participation element. And again, we've seen not only that it was important in Scotland, but there is that future building. The children and young people who were involved 10 years ago in Scotland, some of them are actually now politicians. They are people themselves who will carry this forward into the future and will keep the agenda moving. And again, just generally, we know that progress, as Ursula has already said, does not come immediately. It won't. It certainly won't in Australia. It hasn't anywhere else. But the important thing is that you create those building blocks, those stones, those partnerships, those conversations with adults, with children, and you keep moving forward. That's it. That's me finished. And I'll stop sharing the screen for questions.
Thanks so much, Laura and Ursula. I should have warned everyone that we will be so charmed by your accents that we'll drift off just listening to you. It certainly happened to me. And I'm just noting we're waiting for some more questions to come up, and we've got 182 people online. Please send through your questions now. But while you do, I'll have a little chat to Ursula and Laura myself. So you mentioned about children's rights in policy, and I guess that's one area where we have seen in Australia some progress. And remembering that this role that I have as National Children's Commissioner is very new. I'm only the second Children's Commissioner in this country. And so even the idea of children's rights is fairly, it's quite primitive in this country. Often I say that the term children's rights doesn't roll off the tongue easily here. Whilst Australia, on the other hand, sees itself as a champion of human rights, and particularly for overseas, for other countries, we're often championing rights. But even here we talk about women's rights, workers' rights, consumer rights. You'll hear about those sorts of rights quite a lot, but I don't think I've ever heard children's rights used in Parliament, and I do listen to Question Time regularly, and never by a newsreader or, spoken about in the news. So we're still kind of a little bit shy to go there. And so what we have done, I think, though, is started to recognise that we need to reference children's rights when it comes to policies, policy frameworks, strategies, policy documents. But we still struggle with, what to do with it. And I've been on many advisory committees where that's come up. Or, well, here's a paragraph about the convention. Where should we put it? And it's like it's about getting it in the document somewhere. That's sort of where we're at the stage where we're at. So I think it might perhaps be helpful for everyone to hear from you a little bit about how children's rights can actually help with policy reform, even short of putting the convention into legislation while we continue to work on that. What is the benefit of properly considering children's rights in policy reform?
I mean, I'll go ahead, Ursula, you can supplement. The way to do it, of course, I haven't mentioned, but it is one of the general measures. It would be through a proper child rights impact assessment. And I don't think that you have that, as far as I understand.
We do. Actually, that is one of our achievements. So my team developed one with the help of UNICEF. They gave us a bit of funding. And so That, and it's been referred to in two parliamentary inquiry, or a parliamentary inquiry and another a COVID inquiry, where they've recommended that it be used widely by government, but it's not being used yet widely by government.
So if it was routinely rolled out and there was expertise building in that, that would be fabulous, because that is how, that is the best way to get it in policy, is to do a thorough, pre-policy and evaluation of policy impact assessment. And that requires more than, that paragraph that you referred to, Anne, that standard paragraph that we see slotted in some policies all over the world. Australia's not alone, because it requires substantive engagement with the text of the convention and the wider jurisprudence of the convention on the particular right. So that if there was that level of engagement, you would get better policy. And I didn't spend a lot of time going through the 6P headings. But one of the things that does is not just, of course, have the substantive engagement that it's about process. It's about encouraging cooperation and partnership. All of that will give you better policy for children. There's just no question of that. So more child rights impact assessment would be a wonderful start, Ursula, would you like to add to that? Because you've been very involved in Ireland as well in some of the policy development. Yeah,
and what I would say is what you're describing, Anne, is not very far removed from where we certainly have been, and in countries where we've seen not necessarily overt opposition to the convention or to children's rights, but just a level of apathy or a disregard or a lack of prioritization for children's rights. So it's not uncommon, and we have done other work where we found that particularly NGOs and others who know their audiences, and this might answer some of the other questions as well, learn to adapt and mold and as we've said, chameleon-like, adjust their language and their style and their approach to their audience. And some will find the language of best interests simply a gateway into those conversations about child rights. And we know the best interest is in Article 3, that is part of the rights-based approach, but it's softer language. It's not some see the sort of hard edge of children's rights in other areas. And so sometimes what we see are those conversations really important to coalesce around, the idea of what we have in common being really critical to advance those discussions. The other thing I would say to the raising of awareness on in particular to the political system, is encouraging advocates, NGOs, your office, all of those who engage with law reform, policy reform, to consistently and systematically raise children's rights perspectives and children's rights issues in those consultations, in the dialogue, in the submissions. I think it's really important to not just include your paragraph, but actually be the ones who show what this means. And of course, working with children in that respect is really powerful. Having them alongside you as advocates, as well as human rights defenders in their own right, and so on. So I think it's really about demonstrating what you expect to see elsewhere and how you engage and how you make submissions and so on, that becomes, I think, just the norm. And yes, some will turn off, but actually you will persuade others who are willing to listen, and that's again an incremental process.
That's excellent advice from both of you. That idea, Ursula, of normalising a conversation about children's rights, because I think in Australia there's an awkwardness, and even amongst advocates, there's a bit of contention about whether you lean in on the rights conversation, or, as one of the people in the text asks, about should we be talking about well-being instead. And so because Australia we're happy.
Don't start me on that one.
No, and you've partly addressed that, but do you want to say a bit more about that thing? Because I think in Australia we have a comfort with not that we do much on it, by the way. That's one of my issues, that we're not prioritising child well-being in our country.
Either.
But that aside, from a language perspective, we have a level of comfort with it as opposed to rights. And I think even amongst the advocate community, we kind of go to well-being because there's a comfort zone there, and we don't want to alienate our audience straight away, right? I'm speaking personally now. I feel this too. So do you want to say a bit about that?
Yeah, I think I will. I've written on this quite a lot. It's something I feel quite strongly about. Ursula can kick in and probably be a bit more moderate on it. You're not alone. you know, everywhere in the world, in the English-speaking world anyway, when there's discomfort using the language of rights for children, people resort to other language, and well-being is the word of choice, really. And there's nothing, of course, it's really important that we promote children's well-being. Nobody could be against that. It's incredibly important. But rights is a route to doing that, you know, and it's a different thing. You know, well-being comes from a very different background, you know, about child development. But ultimately, the major difference is that it's not an entitlement. You know, it's not an entitlement, and it can't be. It's not worded that way. It's not framed that way. It doesn't have redress. It doesn't have that level of law that we're talking about tonight. I'll not say more. I've written a paper on it. I'm very happy to share it if anybody wants to do that. I call it a dilution. It's a dilution. It's child rights light, you know. I appreciate sometimes, and we've heard this again at research Ursula and I've done in Ireland in the past, people like to use that language because they don't want to turn off their audience. And I understand that for pragmatic reasons, you might not want to go in and use the language of rights with certain politicians or certain people or certain, and that's up to you because, you know, those of you who are doing advocacy, that's fine. But I don't think you should lose it yourselves. I mean, it's a different thing. And it's not a substitute. Ursula, do you want to add something to that?
No.
No? Good.
No, I agree. And I've written separately on the best interest principle, and I you know, about it being a gateway to rights, and that paper changed direction a number of times when I was writing it, because I started off in the position that this was really not rights. There's no reference to rights in Article 3. It's not, it's, you know, so, but we certainly saw in our work that it is useful as a consensus principle around which those who otherwise might disagree about rights can coalesce. And once you're in the room, you start having the conversation, moving on, and also not to assume that everyone understands the difference between well-being and rights and welfare and best interests. You know, we do, because we research it and work on it all the time. But it's, you know, bringing people along that journey knowingly, I think, is really key.
Fantastic. And we'd love you to send us links to those papers. I should tell the listeners that you've already generously shared links to work that you've done, which I think Liz is going to put up in the chat if it's not already there. There's lots of work that, as I said, you've both done enormous amounts of work. We'll share that with everybody. Now, so the questions have started flowing in. I'm really pleased to hear. Politics is coming up quite a lot, and so the question of politics and also the question of how to involve children, and some specific question to you, Laura, about your model. But let's start with the politics side of it, because this is something that is a particular issue for me. Where I am frequently told things like there's no votes in children, or that there's no electoral benefit for addressing the rights of children in this country, so that doesn't help them win votes. And so what we see at the state and territory level is that what helps them win votes is to be tough on crime. And we've seen that in the last few months very starkly, and that will continue. That's at the state and territory level. That youth crime is actually, whoever sounds the toughest has the best chance of winning, and that's an ongoing problem we have. At the Commonwealth level, youth crime is not our problem, they say, and therefore they're not involved at all. But equally, they would say that there's actually no benefit electorally for engaging in children's rights. So let's talk about that a little bit. What can we do? What's your advice for us poor Australians dealing with this situation that we've got, this disconnect?
This one for you, Ursula, with your background in youth justice in Ireland.
Well, yeah, I mean, I've worked in youth justice, and one of the great advantages of the work that you can do in youth justice is that it is one of the areas of child rights where there are more international standards. There is a greater level of consensus than you'll see in probably any other child rights issue. It's actually, there's an enormous body of consensus around what is child rights based approach to youth justice, to children in conflict with the law, to youth detention. So you can decide you don't like it, but you can't really disagree with it, because the other really good thing about youth justice from the rights perspective is that the research all aligns. So all of the decades of research that's been done in this field from every discipline all reinforces that children are different, and all the circumstances that bring them to a point of coming into conflict with the law also demand a different approach, a separate, distinctive approach that focuses on them where they are, but also focuses on the importance of supporting them away from offending and away from the harmful circumstances they find themselves in. There's a whole body of law and body of research and literature that coalesces around all of that, which I think is really, really compelling. And so what I would say in relation to the political, and we've managed to do in youth justice, the closest thing to a rights-based approach, I think. And that's not that we don't have the politicians that you do. We have some. It's not quite as perhaps extreme in places, and we live though beside a neighbour that has those tendencies, so we understand them. What I would say is that in all of those issues in relation to child rights, it cannot just be, if you like, child rights advocates who take that on. This has got to come from those who work with and for children all day, in classrooms, in health centres, in hospitals, in the places where children live, all, in their family lives, where they come into contact with the justice system. These are children's best advocates as well as their parents. And so the idea that it's a divide and conquer, that only a certain small cohort believes in and advocates for child rights, is simply not true. And I think that's the challenge in those conversations. Those are really important, again, in raising awareness and bringing on board and bringing with you this wider coalition that Laura mentioned earlier on. Is really critical, because what we found for example, when we talked to professional, say, social workers in Norway, they talked about the convention being their law when it was incorporated. This was now theirs, not this foreign treaty that their government had signed. This was their law that governed how they worked with and for children every day. And they were able to talk with really, compelling and authentic stories and narratives about why that was so critical for them. So it's widening out the remit and writing out the focus of those who have these conversations, so that it's not just you sort of one dimensionally, as they might see it, talking about these issues from your perspective. This is actually a huge sort of movement which we've all been in for 30 plus years, looking at how we bring this wide coalition with us in the process.
Laura, did you want to add to that?
No, I'm conscious of time. I can take some questions on participation. I noticed there was a bunch of them there, but I agree with what Ursula has said. Yeah.
Okay, look, I'll just come back on what Ursula said, just to say that that's very interesting. Well, it's personally very interesting for me in this role, because I get invited to speak a lot to conferences of the converted, if you like, or I consider them the converted. So they are the social workers, the psychologists, the people working at the front line with children, and I do think that is I guess these are the sectors that really they understand child development for a start. We consider them the safety and well-being sectors, if you like. If we could help them to move to become the child rights people as well, as you described in Norway, then that broadens the base and the momentum. And of course, they're also speaking to government and politicians all of the time about their work, which they are in the front line of seeing, the things that go wrong every day. And if they can start to link the rights perspective to their work in the way you beautifully described with Norway, I feel very inspired by that, because I often say to them, stuff that other people don't know, especially politicians. Child development for a start, that's their superpower. But what we can do is link child rights knowledge to that superpower, and then we're really heading. I think I can see that.
And we just to say we've just a colleague and I, Jonathan Todres, in Georgia State University in the US, have just finished a collection on child development and child rights, bringing together child development expertise with child rights expertise. So it's really having those conversations, to your point about not speaking always to the coalition of the willing, getting yourself into those spaces that are unfamiliar, where you have to explain yourself and justify and advocate and listen. You know, I think that's really important.
And can I add to that? Because, sorry, it does link to the child participation point. Can you hear me?
Yeah, I was just going to say, Laura, before you go, Ursula, your book's coming out in January. I think you said it's being published in January. We'll put that in the chat as well. And yes, Laura. So yes, you're right. There's a bunch of questions about child participation, and one of them I think is from someone from that frontline service sector. Who's saying that there's a challenge about organisations being a bit risk averse in terms of going towards incorporating the voices of children, but there's a bunch of other questions. I'll hand over to you, Laura, to talk about.
I haven't looked at all the questions. I just saw some coming, but I wanted to follow up firstly on the point that you made about, I have spent quite a lot of the last 10 years talking to every profession that works with children. And leaving aside the point that was just made, almost every one of those professional bodies, whether it's early childhood, pediatric nurses, teachers, social workers, they're really important people, in terms of children's lives and, manifestations of the state, people working for government. I find that child participation, child voice is usually in their professional competencies. It's in there somewhere. It's in their professional training. Maybe they don't kind of totally see it in a child rights way. And what I have found that when these professions want to do that and they want to do it well, they have concerns about safety and, can leave that aside for a second. But for me, when I'm in those spaces, and I've worked in many of them with people all over the world, and they, to me, it's an entry point. Child participation is a good first point, because once you're talking about that, and there's none of them are not committed to doing this, then you're explaining it as a right, and then you're connecting that one human right to all the other human rights, and showing that child participation is a way of delivering, education, adequate healthcare, justice. And I think so. It's a really good starting point. And then often what I find is those people have started to get into child rights more generally, want to know more, want to understand, and that incremental movement towards seeing themselves not a well-being person, but a person whose job it is to uphold child rights. That's just to connect to the point Ursula was making. I'm not sure, there were a bunch of questions coming through about child participation I'd like to take it back to incorporation, if that's okay, because that's what we're here for. And I'm not here to do the whole Lundy model talk. You can find that online, lots of YouTube videos. But on the incorporation point, it applies to law. It applies to law. And I've already said that if you're going to have a conversation about incorporation, you want to have children on board shaping that. But let's take it just on to, what Ursula and I would see as an incremental approach, your ordinary domestic law. It's changing all the time for children, and children should be involved in shaping that. We obviously saw your law change this week. It made world news, on your social media ban. There is an absolute requirement that children should be involved in shaping that their perspectives should be heard. And again, there are really nice examples across the world of that happening. It's now in the same way that we're moving towards incorporation, certainly in Europe, of course, where we are both based. It's increasingly unacceptable not to do this. And I think maybe you're there, maybe you're not there. But if you have child rights impact assessments, an absolute requirement of a child rights impact assessment for a new law is that you engage with the perspectives of children and young people again. So, there's nowhere better in the world, and it's not just because Ursula and I are in Ireland, but there's nowhere better than Ireland at the minute, because of the things that Ursula said. The Irish government took it seriously. They have a national strategy in child and youth participation. They have a national framework in child and youth participation. They have a national centre of excellence called Hub na Nóg, where you will get lots and lots of examples of what they've done, including on law. So I think it's really, you're not there yet, but there are lovely, lovely examples of that happening elsewhere.
Thank you for that. So there were some questions about the Hague Convention, which is perhaps a little bit off to the side, but you may be right across the Hague Convention, and might want to comment on well, this question really says, why is there so much resistance when asking for legislation that says the best interests of the child and the best interests of Indigenous people and the Indigenous child must be fully assessed and held as primary and determinative factor during Hague Convention proceedings? Do you have a comment on that? I know it's a particular issue, but you may have a comment.
Do you have one, Ursula? I'm not a Hague expert, but
other than there is no substantive assessment of those issues under Hague, and that may be part of the resistance that you're talking about. But no, I mean, I think that it's important when looking at any law to try and understand where the opposition is coming from. And in particular, I suppose, where I suppose it's perceived to be a zero-sum game, and certainly and this is where we found, and Ireland would be a good example of this, where the opposition to children's rights comes from family lawyers, which can be sometimes hard to understand, but there are a whole range of issues that have to be worked through to understand what that's about. And I'm always mindful of our first ombudsman for children when asked all these questions, a regular question about the sort of opposition between parents' rights and children's rights, used to simply say, I've never seen a parent who did not want the absolute best for their children. And if that is manifest in children's rights and a rights-based approach, that is what parents want. And I think that's, while it's not true universally, it is absolutely true of the majority. And I think those kinds of myths really don't help don't help the cause, and I think we have to try and look behind what people are really fearful of in all of this. The sense that it is a zero-sum game, that in articulating rights for children that somebody else somehow loses out, which is we know is simply not the case.
Thanks, Ursula. There's a general question about where we're heading globally, the direction of travel, I think it's described as, and particularly also about the optional protocols, which I know have been problematic. Would you like to comment on that?
The general direction of travel on the human rights and child rights.
Well, we know illegal enforceability of children's rights.
Okay, that's more specific.
Are we seeing more countries incorporating, building in that legislative accountability?
Yeah, Ursula, you want to say something? That was your kind of first point, but we can draw on the other examples. Yeah.
Yeah, and I might just pick up in relation to the optional protocol and the communications procedure is the movement around access to justice for children, actually, which has really become centre stage. And obviously we know the general comment from the committee on access to justice is really looking to position children centrally in enforceability. And the question I suppose the question really of the child as a legal actor, and those are sometimes difficult concepts to understand, but I think we all, I suppose, but they're vital to move us from a paternalistic perspective of children as the individuals to whom who are subject of proceedings, who are parties. And then those who are entitled to litigate and are actually are legal actors in all the different ways the legal system impacts on children. So I think the sense of justice for children also is starting to resonate much more powerfully, and I think the more we engage with that, the more it strengthens the child rights approach. And it relates to the growth in interest in the optional protocol as well. Ireland is a party, although we've yet to be have any cases in the committee.
We also have General Comment 27 coming, so there's a huge conversation worldwide about access to justice. And I just want to give one concrete example of that, again, related to incorporation from Scotland, because Scotland's a really interesting place to watch now, when you have that full direct incorporation. And what happened, I suppose, Ursula and other child rights experts became very busy because of Scotland, because even before it fully incorporated, and even when it was challenged, people who weren't necessarily working directly with children started to realize they were a public body and this was coming down the line, and they started to prepare. And one example, Ursula and I had very interesting conversations, not with the children's ombudsman, but with the ombudsperson, with the general Scottish ombudsperson, the general ombudsperson public complaints office. And they were saying, well, if this comes down, we should really be rights compliant. So we should have child-friendly complaints mechanisms, shouldn't we? So Ursula and I were like, yes, you should, and so and she did, she worked with children and young people, and if you look at her office, there are child-friendly complaints mechanisms to the general public ombudsperson, and that is one of those consequences of incorporation.
So I think it's very interesting for us to hear how the countries that you've referred to, the journey that they've been on. And I think it's reassuring. Thank you for your reassurances that we haven't dropped off the edge of the world somewhere, but there are other countries facing similar challenges. And I think one of the really exciting things is to hear about these stories firsthand from people like yourselves who've done work with these countries to bring that picture and that vision into our country so that we can gain hope that it could be different. I think being an island country a long way away from other countries, I think we do tend to be a little bit parochial and often feel that how it is the only way it can be. And so it is about, I think, unleashing that vision that it could be different and harnessing those other people that perhaps are not rights advocates yet, but they might be, certainly children's advocates, to help them on that journey. Before I go to the next question, I just wanted to answer a question someone was asking about our Child Rights Impact Assessment tool. Yes, it is available online. I think if you just put into the browser Child Rights Impact Assessment, it should come up. If it doesn't, put in Australian Human Rights Commission as well. And if you're really desperate, just write to me at kids@humanrights.gov.au and we'll send it to you. Look, we are starting to finish our hour, but I wanted to perhaps open up a little bit. This is a difficult question, I think. We've talked a lot about the influencing, the persuading of politicians, the harnessing of the advocacy community, or broadening the advocacy community, which in fact is what the Act for Children campaign, as you noted, Laura, is all about. But there have been some questions in here which I thought we would get about what's happening in Queensland, where the politicians have themselves admitted that what they're doing is in direct breach of their own Human Rights Act. So, this is in their statement of compliance. They've said it's not compliant. This bill is not compliant, but we're doing it anyway. And so I think some of the listeners might be interested in your views on that pretty dire situation that we face right now.
Yeah. You want to go, Ursula? Do you want me to? What do you think?
You start. I'm thinking.
Well, I'll just start with the one kind of concrete legal point that is really important, is that ultimately it is the Commonwealth Government who's responsible for ensuring this. They ratify the treaty, it ratifies the treaty, and it's responsible for ensuring that all the states comply. So there is something to be done there. And, I'm not saying they will do it, but it is actually their responsibility to ensure that there's child rights compliant law and policy throughout Australia, including in Queensland. So they should be doing something or saying something. It will come up when Australia goes back to the Committee on the Rights of the Child, there's no question, to have a direct, thing. We're not going to do it. It will, but maybe that they won't care, that won't matter. But I think, it clearly is you know, if I were there, you know, if I were in Queensland, and I have many friends and colleagues in Queensland, you know, what does the human rights framework give you? It gives you this point for advocacy. You have something to call it with, you know, you have something to call it out. You have, as Ursula said, all these international standards that are saying this is wrong. And Ursula, I'm going to pass to you on that because that's your area of expertise, the actual area that they've breached the convention.
And well, at least they're being honest. You know, there's no pretense here that what they're doing is some kind of fudge. You know, that's the first thing I would say. It's pretty dire, but it's and they're not alone. Although most other governments simply don't explain themselves and don't have to explain themselves that do that. Obviously, they're not typically the ones we want to be associated with, but nonetheless, I think that's the first thing I'd say. The second thing is to endorse the comments that Laura made about advocacy. You have a framework. We found in our, as you know, Anne, I think when we were reforming our youth detention in particular, in introducing a rights-based approach to child detention in Ireland, we found the international community hugely important. We drew on it all the time, sometimes not when we wanted to, found that international bodies, our inspection bodies, the committee and others, their interest in us was really important, reminding those who were responsible for the policy and lawmaking and so on, decision making at a national level, that there were others watching. And I think that's really important. So leveraging all those opportunities, not just the CRC, but the other treaty bodies and other mechanisms that you're part of. So that's the second thing. And I think the third and the related piece is you've got to document all of this. You've got to document their views. You've got to make sure that because ultimately, worst case scenario, you cannot have it said that nobody knew. And I think documenting what the breaches of the convention, the willful setting of the law against the convention, and what that means for children and families and communities is really important. Because all of those things don't matter when you're trying to win a vote or win a political race, and so those I think are important reminders to have. That is documenting, engaging with the international community, and making sure that you're leveraging your academics, your NGOs, your all of your coalition partners around these issues in a really serious way.
Thanks. And as you were speaking, I was thinking that maybe there's actually an opportunity here, because it is such an extreme move. In a state where we already had problems, fair to say. This is actually just not a party political thing. Both sides of politics across Australia are very poor on children's rights, and that's certainly true for Queensland. But a lot of people will say because they won the recent election and they had the slogans of, that they knew, they're not doing anything they didn't promise to do. They actually won because of these promises. So there's, I think, that can lead to a sort of a situation where people go, oh, well, this is what people wanted. What I would say to that is that people want to prevent crime by children, by anyone, and have safer communities. And what we now need is, now that they're the government in power, they should be looking at the evidence about what actually works to prevent crime by children, and if we can link that to the human rights of children. Children are part of the community. They themselves are victims of crime. They need to look at the evidence, such as in our Helpway earlier report. The other thing is, I'm often asked when I'm speaking, what can I do, what can we do about situations like this? And so I don't want to lose the opportunity to say that everyone listening can actually go to their local member of parliament. Laura said it, this is the Commonwealth government responsibility ultimately to uphold the rights of Australia's children. If you're not in Queensland, you can still talk to your federal member. Go and tell them you know, it is not okay what's happening in Queensland. And if we get enough pressure on these, particularly backbenchers, you know, that they start to see there is a community of interest out there that wants to improve children's rights and is distressed and outraged and angry about what's happening in Queensland. On that note, I think we've run out of time for questions, and I just I need to say a few wrapping up things. We've got in the chat some more questions which we'll record and we'll use to guide future roundtables. So thank you for all of those questions. We've also put in there the resources that have been mentioned for you to follow up on. So thank you, Ursula and Laura, for an amazing conversation late at night for you. I can see our numbers went up to over 190 at one point. I know that, you know, over 400 will be watching this recording, and you've been very inspiring for us so far away from Ireland. It's been very nurturing to be able to hear from you your advice for what we can be doing in Australia. It's been, I think, a very rich and nurturing conversation, and you've been very generous with your advice, and it's been very inspiring. So on behalf of everybody, I'd like to say a very sincere thank you to the two of you. Thank you. I'd like to also thank Adam and Liz at ARACY for their support with hosting the webinar and their tech support. Thank you to all of you who are listening for joining. I wanted to let you know that we have some exciting news, that the Act for Children campaign now does have a website as of this morning. I think there's a link to the website in the notes, and on that website you'll have some information about what Act for Children is all about. It's just the beginning. This website is the beginning of the first phase, really, of this campaign, and the site's going to grow to amplify the voices of young Australians, host roundtables and other events, and it's going to be a hub of activities for igniting collective action, particularly, we hope, in the lead up to the next federal election next year. We do invite you to join this movement alongside the other organisations who already have their logos on this website. And together, I think we can create a nation where Australia's rights, where children's rights and wellbeing are at the heart of everything that we do in Australia. I think that's the opportunity within our hands, particularly those who are joining us today and all of our colleagues out there. So watch this space for more great events next year. We'd love you to join the movement. And I'd like to finally say, have a fantastic holiday break, everybody. As you may know, Laura and Ursula, we're about to break for our big summer holidays. So everyone's kind of very exhausted and winding down. So I wish everyone a fabulous holiday break, and I look forward to collaborating with all of you next year. Thank you very much.
Thanks very much, everybody.
Bye. Bye, everyone.